We have both sharp disagreement between the various members here on the dais and a great deal of agreement. Much of what you just said in your opening statement would be paired perfectly with my views. But there are some items that I think are critical that we ensure as we see what's wrong with shadow docket, that we also appreciate what is right. Many would say that a last-minute decision by the court not to stay the execution of a prisoner is inherently wrong. However, the alternative could easily be a simple refusal to grant cert, therefore condemning the prisoner without even one last look. When we consider over the years the court's very important decisions that they have taken on when and how you can execute a convicted person who's been sentenced to death, in fact, it's those very novel last-minute calls, such as somebody's diminished capacity and the like, that have come to pass. So I think it is critical that we do make sure that we continue to have the justices feel that they can take far more than the 70 cases they take on their formal docket. Notwithstanding that, I share with you considerable concern that during the last administration, this five-fold, as you said, increase occurred. I would say that one of the things that I hope we explore in detail today is the question of whether or not the problem is at the High Court or even at the Solicitor General, but rather at the fair interpretation of what an Article III judge at a district is entitled to rule. None of us here today would doubt that a federal judge, as to the case before him and the plaintiffs before him, has authority to enjoin in every part of the United States, including its territories, within his jurisdiction. The question really is, in many cases, does he have a right to enjoin the administration for their conduct related to anyone not currently a plaintiff in front of the court? This is a question that I believe the Supreme Court must answer. If they fail to answer, or perhaps if the answer is incomplete, it falls to this committee and to this subcommittee to look at a restatement or a reform of the breadth of these types of decisions. I, for one, believe that we do have an opportunity to work together on a bipartisan basis over the next 2 years to craft good and understandable decisions. And I think particularly since the administration has recently changed and, in fact, control of the Congress has changed, we could contrast how we felt during the Trump administration when they repeatedly went to the High Court versus the possibility that in the weeks to come, one or more judges around the country might, in fact, enjoin the administration in a very similar but reversed role, and they may be running to the court. If that's the case, if in fact this very large increase in the load by the court continues, but in a reverse role, then I think there can be no choice but either the court to act or us to act. Further, I believe that in the case of many of the decisions that are now popping up, such as almost every death penalty case having an 11th hour novel review, that there needs to be a greater level of certainty as to when and how a pleading can go, so that in fact we reduce the load to the court. Lastly, I believe that one of your points that is most valid is that although it is unlikely for us to get an expeditious improvement in the transparency of the court, that we have the ability to both ask for, study, and if necessary, require that in the period after a decision, but in the clearness of those days or weeks to follow, that we have a more full and complete reporting. I believe we have an opportunity as a committee to look into a number of bipartisan, mutually selected examples and write the court and ask them to give us, in those specific cases that are of public interest, for a more complete answer, including the process for the voting, who voted, and particularly some of the underlying elements. If we choose cases wisely, I believe we then begin to have the building blocks for what we would ask for and expect in post-mortem of these last minute and often, as is often said, dead of night decisions.